the first thing to kind of understand is that there's really no prohibition on using AI in delivering legal services. There's a lot of gray area about what you can and cannot do. The important thing to, I think, understand is that in general, the existing ethical rules apply. There are really no new rules that I've seen, or very little, I would say, that are new ethical rules that specifically address AI. Another duty that's really important, another ethical obligation, is the duty to supervise. If you are using AI tools, even though it's not a person, you have responsibility for the outcome of using that tool, including the accuracy of the information.
Welcome, and thank you for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, James Gatto. James Gatto is a partner in the Washington, D.C. office of Shepherd Mullen. He is the founder and co-leader of the 110-plus person artificial intelligence team and co-leader of the blockchain and fintech team. He has over 20 years of experience advising clients on AI legal issues and is an adjunct professor at Ole Miss Law School teaching AI legal issues. He is a prolific blogger and author as well, and has been invited to speak internationally by governments, industry organizations, and companies on AI legal and policy issues. He helps companies understand AI legal issues and develop policies to manage the risks, handles AI agreements and transactions, and advises on all aspects of legal and regulatory issues with the development and deployment of AI and open source issues with AI code generators. The webinar presentation that you're about to watch will be approximately 1 hour, and once that is complete, James will be taking questions from the audience. But if any questions come up during the presentation that you'd like for him to address, please feel free to send them in the Q&A box. It should be at the control panel at the bottom of your screen. Now, without further ado, here is James to discuss AI and ethics using artificial intelligence responsibly in legal practice.
Thank you, Dina, for that wonderful introduction. I appreciate it, and welcome everybody. Glad to be here today and to talk through these issues with ethical issues with AI. Nina went through my background, so I'll skip over this. I think the first thing to kind of understand is that there's really no prohibition on using AI in delivering legal services, nor is there an unfettered right to use it without certain safeguards. So in between those two kind of poles, there's a lot of gray area about what you can and cannot do. And that's what we're going to try to sort through today. So the first thing I would say is that it's important to think through the different ways in which lawyers may use AI in connection with their day-to-day activities. And when you think about it, you can kind of break things down into two very significant major buckets, and then within that, there's a lot of different activities. And so as shown on the right of the screen here, there's a lot of different ways in which law firms and individual lawyers are using AI in what I would call non-delivery of legal services. So firm administration, knowledge management, other kind of internal tools that don't really involve so much rendering legal advice, but it's really more the administrative part and the business part of managing law firms and law practices. The one exception may be in connection with marketing. If you're using AI for to create advertisements or marketing materials, you obviously want to make sure that there's no misstatements or errors that are being introduced. But subject to that, for the most part, those are, I'd say, relatively low risk activities, subject to just reviewing, as I mentioned, to make sure for accuracy. So what we're really thinking about when we look at the AI legal issues is kind of really more the bucket here on the left. And there's many different ways. This is not a comprehensive list, but there's many different tools that you've probably all encountered, at least some of these, and maybe using some of these to really support actual performance and delivery of legal services by lawyers. So everything from document review and e-discovery, legal research, contract review and analysis, diligence, regulatory review, predictive analytics and drafting of legal documents. These are some of the major categories of things that AI is enabling to be done more efficiently, and the areas that I think where the most potential concern exists. So what are these existing obligations? So the important thing to, I think, understand is that in general, the existing ethical rules apply. There are really no new rules that I've seen, or very little, I would say, that are new ethical rules that specifically address AI. What we've started to see is guidance from different bar associations on how the existing ethical rules apply when you're using AI. And so that's a big part of what we need to understand is what that guidance is, and that's a big part of what we'll cover today. But I also encourage you to, while we're going to have a pretty comprehensive program today, you're going to encounter fact situations that probably are not addressed by my presentation or may not yet have been addressed by some of this bar guidance. So it's important to kind of stay vigilant for different fact scenarios that may go beyond what we talk about today. And part of the reason for that is, well, the ethical obligations are probably well known to all of you. How they apply to AI can vary based on a number of factors. And it can depend on the tools that are used. The way they work may be different from one tool to another. What they do may be different. So the type of legal assistance they're providing you, how you use them, and the context in which you use them, and other factors may lead to different considerations. Here's kind of a high-level overview of the guidance of which I'm aware. If you look on the left here, you can see that a number of state bar associations, California, DC, Florida, Michigan, New Jersey, New York, and Texas, have issued guidance on the applicability of the existing bar rules to use of AI. Pennsylvania did joint guidance with the Philadelphia bar, and the New York City bar has also, in addition to New York State bar, the New York City bar has separate guidance as well. Beyond the state bar associations, the ABA recently came out with guidance on their kind of model ethical rules and the applicability of AI. And we've seen in some cases, like the United States Patent Office has issued separate guidance for patent practitioners that are practicing before the Patent Office that use AI on the do's and don'ts unique to the PTO rules. On the right side here, there's links to some articles I've written that have kind of go into a little bit more detail in connection with some of the specific bar association guidance that's been issued. For today, I'm not going to go through state by state. What I've primarily tried to do is go through the various guidance of which I'm aware and pull out the kind of the relevant principles. And you'll see if you look at them in any detail that many of the same topics are covered by the different bar associations. And so this is kind of more of an extrapolation of what's kind of across the guidance, and try to distill it into just a single set of principles. There are, throughout this presentation, there'll be some reference to some specific state bars where there's some specific language that'll be there to help kind of explain in greater detail what the bar has said in some cases. So here's a list of some of the, I would say, kind of the main topics from the various guidance that we're going to cover today. And we'll go through these in some detail. So the first couple relate to competency and confidentiality. So we're all aware attorneys must represent their clients competently. And part of this is that you have to have an understanding of the risk and benefits of technology used in connection with legal services. And this is not new. We've seen this when lawyers started using email and e-discovery and cloud storage and storing information on personal phones and other devices. There's been a constant flow of new technologies over time that have created considerations for lawyers and how to ensure that you can use the technology in a way that doesn't violate any of the ethical rules. This is some examples of kind of prior decisions by that have come up in different states. Protecting metadata in transit. There's a California opinion that says if you don't have the requisite skills, you have to either hire someone who does, develop the skills, or decline representation. Various other prior decisions relating to use of technology, including in some states now, there's a requirement for technology training and other requirements to stay competent with respect to the technology that's used. Some of these slides are kind of dense. I'm not going to go through them all. A lot of this is kind of to leave behind for you as far as additional information. So I'll just touch on some of the relevant points in some of these more dense slides. The California bar, makes it clear they specifically call out generative AI and making sure that lawyers understand how it works. And as we'll see, if you're not already aware, people use the term generative AI broadly and as kind of an umbrella. There's many different tools that fall into the scope of generative AI. And one of the reasons that there's a focus on generative AI versus other AI or other machine learning related tools is in part because, as the name implies, the generative AI tools create new content. So AI is not new. AI has been around since the 1950s, actually. It's a 70-year-old technology. It's really starting to see its limelight because of generative AI. And one of the big differences from a simple explanation to help people understand if it's not clear the difference between generative AI and other types of AI is that a lot of the AI up until the last couple of years was really more what's referred to as deterministic. So a lot of it you could think of as analogous to being rules-based. So someone coded in rules and AI or the machine learning technology would crunch a lot of data in accordance with those rules and produce some output. And those outputs were typically very predictable. As long as the rules were coded properly, you could get an output that if you did it manually, you would likely get the same result. And that's what's meant by deterministic, at least at a high level. With generative AI, these tools really do create content. It's not just regurgitating what it's learned. You may have heard the term training of AI models. The AI models are complex. I won't go into a lot of the technical detail, but it's not just taking a lot of content and storing it and then later retrieving it. It's actually training a model using what's called model weights. And the more content that you train on, the more accurate or the more useful these models become. And so when you put in a prompt to say, give me or do legal research on this particular issue, it will not only it will do the research, but it'll actually be able to format the results, distill the information, and create a draft memo for you, as one example. And so while a lot of these tools work well, they're not perfect. And one of the biggest problems is that in some cases, as we'll get into in a second in more detail, these tools actually make up information, right? Because it's not always pulling current information. It's generating stuff based on what it thinks it knows. And this is sometimes referred to as hallucinations. And we'll come back to that in just a second. So what's important to understand is how these tools work, because the way these tools work is that when you provide an input and the tool does its thing and it provides an output, is that sometimes those inputs and outputs are used by the tool to improve itself. So if the inputs are retained and the outputs are reviewed to see if the output was useful or helpful, that can be used to retrain the models in some cases. But the downside to that is you potentially, depending on if you have any confidential information in the input, if that gets sucked into the AI and used to retrain it, some of that information can get output. And there's been situations where that's happened. But these tools work in different ways, and so not all of them work that way. So that's one of the most, I think, critical things to understand is how does the tool work? How does it process inputs and outputs? Does it reuse them, or does it discard that information after it provides you the answer that you're looking for? And we'll look at that and see how that impacts a couple of the ethical rules here in a second. So when we think about as a lead into this, part of this is a requirement that you, of course, can't disclose confidential information of clients unless there's consent or in other limited circumstances. So as I just mentioned, when you use certain AI tools, if your prompt or input to the tool includes anything that would be confidential information, you need to make sure that that tool does not retain that information or reuse it. So that's kind of one of the number one things, I think, from a confidentiality perspective that's important to understand. And pretty much all of the guidance that I've seen clearly addresses this point. And so it's important to not only understand this, but also we'll talk a little bit more later on about developing policies. In many cases, it's helpful, even if you're using a tool that you're confident doesn't reuse the prompts, right? And so you're not impacting any confidential information. In some cases, it's prudent as an extra safeguard to try to avoid using anything confidential in the inputs in the first place, in case there's any anomalies or if you have misunderstood the tool, how it works, etc. So instead of using a specific company name, for example, you might just give a fact scenario without tying it to a company, right? That's a very simplistic explanation or example, but you can envision how you can create prompts that may not have specific confidential information, but you can still get the kind of information you want out of the tool. So that's kind of one of the considerations for confidentiality. So how do you go about determining how these tools work? It's really a combination of things, and it's kind of a layered approach. So first and foremost, most of the companies that are providing legal tools understand the ethical obligations, and most of them are designing their tools so that they're legally compliant and lawyers aren't going to have a problem using them. Those are the legal specific tools, but there's also kind of general purpose tools. And throughout this presentation, I'm not really going to do a lot of talking about specific tools. So I don't want to advocate for or denigrate, specific tools in many cases. But it's important to understand that some of the general purpose tools, there's different versions of those tools. There's a free version and there's a paid version. And in many cases with the free version, they will reuse your inputs, and they'll tell you that. In some cases with the paid version or the enterprise version, they won't. Now, some of those tools, again, are not legal specific, but lawyers use them because they're general purpose tools and they can provide useful benefits. So the first thing to understand is what's the nature of the tool, right? And the second is how do they market it? What do they say about it? But you need to look beyond the marketing materials, because there have been situations where marketing has not been necessarily 100% clear or transparent, because some of these issues with general purpose tools aren't specifically addressed. So how do you dig deeper? So one of the things to look at is the terms of service and privacy policy of these tools. So as lawyers, we love looking at legal documents. Many times the tools will, in the terms of service or privacy policy, will tell you how they handle the inputs. And in some cases, what you'll see is, like with some of these tools, it will tell you that they use it, or that you grant them a license to use your inputs, if it's with certain versions of the tools. So you can get clues from the terms of service and privacy policy as to whether there's legal risks with these tools. And in some cases, you may want to just do some more technical diligence. We have a technology team that vets all the tools that we use, in addition to these other layers of things that we look at. And most firms are doing that right now as well. So, those are some of the ways in which you can kind of drill down from like marketing to legal documents to doing a deeper tech dive on the technology to understand how they work and whether the confidential information is being preserved. This is an example I'll just give. And again, well, I'm not going to focus on too many tools, specifically ChatGPT. Their terms of service are very clear. Again, this is a general purpose tool, not a legal specific tool, but they make it clear that they don't use your content if they receive it through an API, which you do that if you have an enterprise version. But it says we will use your content from other non-API services, basically. So if you're using the consumer or free version where you're typing stuff directly in to a web browser through ChatGPT or a mobile app, you may be exposing confidential information. So that's just a very simple, clear example from a terms of use that make this distinction clear. And so those are the types of things that you want to look for in the terms of service. Okay, so this is just some additional information from New York. I'm going to skip over that. California, again, there's a lot of guidance specifically on generative AI products. They talk a lot about the prompts that are used. And they also talk about uploaded documents or resources to train the AI. And I want to focus here for a second again on another technical distinction it's important to understand is that for a lot of these legal tools, they're trained on legal documents. So it could be SEC filings, it could be other public documents that they're using where the model is initially trained. There's a technology that works alongside of these trained AI models that's referred to as retrieval augmented generation. And if you're not aware of it, I encourage you to dig a little deeper into it because it's a very powerful technology and it's something that actually a lot of law firms are using. And the way that retrieval augmented generation works, or it's called RAGs for short, as the acronym for RAG, is that think of it like this. So you've got a trained AI model, you've got an AI tool that you typically provide prompts to. With RAGs, what you're doing is you're adding to that a set of documents, and typically it'll be your own documents. So internal firm documents, or it could be client-specific documents. There's different ways to configure a RAG system with these different parameters. But in general, what happens is if you've got a library of documents that you've used, prior forms or other agreements or whatever the case may be, that you like and you want to use those as part of improving these AI tools, you can use this RAGs technology. And the way it works is if you provide an input to the tool and say, create a draft of a confidentiality agreement, and then you can put in whatever other parameters you want for that input. What'll happen is the AI tool will first do a search of the document library that's in the RAGs library, and it will find, just like you would do a traditional search, it will do a word search, it'll find the relevant documents, and then it provides those documents with the rest of your prompt to the AI tool. And that combination of information is used to produce a first draft of this confidentiality agreement. So one of the advantages of this is that while many AI tools could create a draft confidentiality agreement without the RAGs part, by using the RAGs part, it's going to kind of what's called constrain the input so that you're getting a version that's based on what you've done before. So hopefully that's kind of clear enough. So it's important. A couple of things that's important to understand with RAGs is you can use your own documents or a client-specific library if you're doing something for the client, if they have a certain set of forms. It doesn't retrain the AI model. It just uses it alongside it. And so one of the reasons I go through a long explanation on that is because these are how a lot of the AI legal tools are working or will work, because having something that's just generally trained is useful. Having something that can use documents that that you've used before that are well vetted and may have specific provisions that you like is even more helpful. So one of the things that's important to understand, though, is you wouldn't want to use, you may not want to use, depending on the facts, documents that you've used for one client, if let's say there's any confidentiality in a RAGs approach where you may be outputting stuff that's being used for another client. So that'd be an example of where you could have a leakage of confidentiality with a RAGs type system. Another situation, and I may have a slide on this later on, but I'll cover it right now, that's important to understand is that if you have an ethical wall set up within your firm where certain lawyers can't get access to certain documents, you need to implement that in connection with the RAG system. So what I mean by that is if there's a team of lawyers who can represent client A but can't see information from client B, you wouldn't want to have the lawyers on the team for client A be able through a RAG system to access firm documents that were associated with client B. So that's an important limitation that needs to be implemented with a RAG system when you're using it within a law firm. Okay, so moving on. Another duty that's really important, another ethical obligation is the duty to supervise. So we're all familiar with the fact that as a lawyer, if you're working with non-lawyers, whether it's your secretaries or other paralegals or other non-lawyer professionals, you're responsible for ensuring that the work they do is ethical and legally proper in many respects, right? That it's accurate, et cetera. You have ultimate responsibility. And there's been plenty of situations outside the AI context where attorneys have faced ethical ramifications for not adequately supervising these non-professionals. In the context of AI, while AI is not a person and is not deemed to have traits of a person, you're responsible for ensuring that if your staff uses AI, you're still responsible for the outcome of that. And I believe also if you are using AI tools, even though it's not a person, you have responsibility for the outcome of using that tool, including the accuracy of the information. As I mentioned earlier, not all these tools produce accurate outputs. And that's been one of the number one things that's led to ethical issues with lawyers using AI to date. And so one of the ways you want to ensure that you can help with ensure the duty of supervision is complied with is I strongly encourage law firms and or lawyers to develop specific policies, written policies on the use of AI by staff and ensure that there's adequate training on them so your staff understand the legal issues and where the potential pitfalls are, and that there's a policy to make sure those risks are mitigated. Speaking of sanctions, so many of you are probably familiar because it made the headlines of not just legal publications, but general publications. In the Avianca case, one of the first situations where an attorney was sanctioned for using AI without proper supervision and or understanding how the tool worked. There was an attorney that used an AI tool to do legal research and found that there were some very favorable cases that supported the position that the attorney was looking for. And being a knowledgeable attorney, knew he needed citations for that case. So he asked ChatGPT, in this case, as the tool he used, to provide the citations, and it did. Turns out, though, those cases were made up and the citations were made up, but those were all output from the AI tool, and he didn't actually review that information. And he cited those non-existent cases to the court. And then the rest of it's kind of history. The court, obviously became aware these weren't real cases, and the attorney was sanctioned for doing it. Wasn't intentional, just lack of knowledge or understanding. But the court found that was an ethical violation. There was another case where an attorney, in connection with representing a rapper who was appealing a conviction, this arose in connection with the appeal. The lawyer in the underlying case used an AI tool to draft basically the closing arguments. And according to the rapper on the appeal, he said that the attorney, after he hired a new legal team, and he moved for a new trial, he said that this lawyer in the underlying case uses AI program to write his closing arguments, and it turned out there were frivolous arguments in there. There was misstatements of facts. There was various things that were omitted that should have been in there. Long story short, there was arguments that the lawyer that had a conflict of interest because he also had a financial stake in the company that built the program that he used. And so these issues kind of arose on the appeal. We've seen cases where there's a case in Southern California where a law firm was sanctioned for submitting a brief that was, as the court found, replete with inaccuracies, and an entire body of law was fabricated. In this case, though, which is interesting, and this is another key takeaway, I think, is that the lawyer kind of owned up to it. The lawyer didn't try to make excuses. The lawyer said, there was a failure here. We own it. We accept responsibility for it. And the judge imposed a sanction of $999, which is significant because at $1,000 or more, there was a reporting obligation to the bar. So, there've been other cases, though, where lawyers have tried to hide the fact that they used AI and the outcome was not valid. In some cases, lawyers submitted a brief and became aware of the misinformation and didn't take it on themselves to notify the court. In other cases, there's been lawyers who have the court has said, hey, these cases don't really exist, and they tried to direct the blame elsewhere instead of accepting the blame where it belonged on the supervising attorney's part. And in those cases, the courts have come down with a little bit more significant penalties. Just one thing of interest here is that there's at least one case, as indicated here, where a pro se applicant used AI in representing themselves, obviously, to the court, and the outputs were, again, fake or non-existent cases, and probably not knowing it, but the applicant got chastised by the court, and the court said that even with pro se applicants, they have to adhere to ensuring the accuracy of information that's submitted to the court. This is a case where a Colorado lawyer was suspended for using an AI tool to write a motion in an area that the lawyer had never practiced before. So they tried to use this AI tool to kind of supplant or kind of provide knowledge that the lawyer didn't really have. And the court found that, that was grievous error in many situations. Not only was the information incorrect, but the lawyer didn't have the capability to actually verify the information was accurate because he just didn't know that area of law. So that was a combination of issues. Again, from the California State Bar on the duty to supervise, as I kind of mentioned earlier, but this just kind of reinforces the point. They strongly encourage supervisory lawyers or firms to establish clear policies on generative AI for their non-lawyer staff that are using this, and to provide proper training. Okay, so some of what we've covered so far kind of touches on this as well, but another ethical obligation is candor towards the tribunals. You can't knowingly make a false statement, and various related issues. You can't submit evidence that's known to be false. In this whole category, the concept of hallucinations, as I mentioned earlier, and it was kind of brought out in some of these earlier cases. The short of it is you have to fact check the output of AI to make sure that it's accurate. You can't blame the tool for providing wrong information. You're responsible. I don't think we need to say a whole lot more about it, but notwithstanding, I think the clarity of this obligation, as we saw from some of the examples I gave, the majority of the ethical actions that have been taken against lawyers for use of AI improperly are based on the failure to supervise and the failure the failure to check the output to ensure the accuracy. So that should absolutely be like job one when you're using AI, is make sure it's accurate. There's some articles, that I've seen that I think kind of put this characterize it in a way that easily understandable, is that the output of AI is not a primary legal source, right? At best, it's a secondary source. And just like with other secondary sources, you wouldn't just rely on it directly, right? You'll go to the underlying information that the source is referring to, whether it's cases or other information you're going to rely on to verify it. You need to do the same thing here. Okay, so this is all pretty clear. Let's go to the next topic, which is kind of the client relations issues. It implicates two ethical obligations at a minimum. One is the duty to communicate, and the other is reasonableness of fees with clients. So on the duty to communicate, there is, I think at this point, perhaps some debate still on whether or not you have a affirmative obligation to tell a client you're using AI. Certainly if a client asks, you have to give them an honest answer. Certainly in some cases, there are clients that have taken the initiative and in provided information to their firms saying, we don't permit you to use AI. I think there's a smaller number of firms of clients that kind of take that approach now, but that had been an approach. And so obviously you must take client direction. There's no I think we'll debate about that. But I think where the kind of the open question is do you have to tell a client you're using AI? I think the better practice is, when in doubt, communicate with your client. If they don't have a problem, it won't be a problem. If they have a problem, it's better to know before you use it than to use it and find out afterwards that there's a problem. We see this with other technologies. You don't necessarily tell a client about every piece of technology you're using. But again, I think the reason that this issue arises here is that there's issues with generative AI, for particularly generative AI, that may arise that go beyond what some of the traditional issues are. So I think that, it's better if there's a concern to raise it with a client. Okay. And there's certain situations where there may be some risks in using AI, but there may be great efficiencies in using it. So for example, if you're going to use AI for a document review, what if the AI tool misses something in the document review? If you have a conversation with the client ahead of time and tell them you're proposing to use this tool, here's what the tool is, here's the pros and cons with the tool, and that there may be some risks, but here's the cost savings. If the client agrees and decides to all that with full disclosure up front, that may help protect you if something does get missed. So I think that there can be benefits in certain situations to being very clear with clients and confronting the issue ahead of time. Okay. So fees. This is an issue. Most of the guidance that has been issued so far basically says that if you're telling clients that you're billing them at an hourly rate, if you save hours by using an AI tool, you can't bill the value of the hour. You have to bill the actual time that you incurred. That shouldn't be too kind of remarkable. I think most people should kind of understand that, and that's pretty straightforward. The question is, over time, kind of where does this go? I think, again, in communicating with clients, there can be a cost savings associated with using AI, but there's also an investment that law firms have to make. And so where is the balance going to come out between the investment that law firms make versus the fees that the client saves? Is there some way to meet in the middle? And that's where you can get into alternative fees with clients and things like that. But if you're going to bill in any way other than billing the actual time spent, then you really need to have that agreement with the client before you do that. That's kind of the key takeaway from the guidance on fees. the California bar, again, they have just amplified what I basically just said. And here's some additional information about that. Okay, next topic, the prohibition on harassment and discrimination. So lawyers, cannot engage in harassing or discriminatory activity. Again, that's not anything new. How that relates to AI, this gets a little more complicated in that depending on what information a tool is trained on, there have been a number of situations where AI tools have, not that they've been programmed to do this, but just because of the, maybe the lack of forethought on the training material, they've produced outputs that are discriminatory or harmful to a particular group of people. So it's important to understand that these tools can exhibit bias or other types of harms around that. And that's one of the things that lawyers need to make an attempt to ascertain is there an issue with respect to that with the given tool? And it could be based on, if there's prior stories about the tool producing an output that's a problem. You may want to ask the vendor how they train the tool, how do they ensure there's no bias, at least you do some reasonable diligence in connection with this to make sure that it's been something that's been thought about. There are, I won't get too far down the rabbit trail on this, but there are like best practices that are developing for training of AI tools. The National Institute of Standards and Technology, or NIST, has published a lot of guidance. One of the things that we typically ask is, and that's kind of considered the gold standard, if you will. We, typically we'll ask, vendors, whether it's a tool that we're looking to use, or if I'm representing a client and they're deciding whether to approve a tool under their AI policy, is, what are the protocols you use for ensuring, that you're training on data that's representative in a way that won't create bias or discrimination. And if they're not using the NIST guidelines, you may want to dig a little bit deeper. If they are, it doesn't mean that there's not a possibility this will happen, but again, there's a level of reasonableness to the diligence. It's not necessarily that you have to ensure that there's no output, but just that you've taken steps, I think, that are reasonable to ensure that there won't be. And certainly if you become aware that the output in some way is discriminatory or would create harassment or harm against a particular group, you don't want to use it. There have been some tools, this one in particular called Compass, that had been used for a while. It's an AI-based tool that was designed to predict the likelihood of recidivism among criminal defendants. It was later shown that that tool produced a biased result based on the demographics of the typical prison populations. And so that tool, kind of came under fire for those shortcomings. There's other tools that have been used, again, in the criminal context, for what's called predictive policing. These have been tools that have been used, for example, to identify people that may match suspects in certain crimes that have occurred. Some of these have led to a lot of them are based on facial recognition, and some of these have led to false arrests. And part of it is, alleged that the tools weren't designed well because they weren't trained in a way that was on a representative population of faces. It was really more certain demographics of people. If you want more information on this, I strongly encourage you to watch this documentary called Coded Bias. It really does a good job of highlighting how bias can creep into AI with some real world scenarios. Very powerful, very informative, not necessarily ethics based, but it kind of ties into this topic. As I mentioned, NIST, if you want to understand more about the details of kind of the way in which these tools should be trained, the risk management framework from NIST is a good document to take a look at. And again, the California bar, I think, has pretty clear guidance on this, that They make it clear that, generative AI can be trained on biased information and that lawyers have an obligation to, kind of ferret that out. And there's kind of an ongoing practices. You need to continue to update your practices. NIST actually just published updated guidance. And so you obviously want to look at the most current guidance to stay informed and do your proper diligence. I think I touched on this earlier, so I'll skip this. This relates to if there's ethical screens using systems like the RAG systems I mentioned, or otherwise you want to make sure that you don't have any, the ability for a generative AI system to give lawyers access to information that they shouldn't, even within the same firm. Okay, so moving on from lawyers to courts. So how are courts responding to the use of AI by lawyers? The answer is it kind of varies. Some judges are issuing local rules or specific rules for their court on different aspects or different approaches to AI. Some require certifications that either you're not using AI, or if you're using it, you certify that you've checked for accuracy. In some cases, there's an affirmative obligation to disclose if you've used AI and what portions of the text of a brief or whatever other filing you use to create, that you use the AI tools to create, and certify that you check the output and there's no confidential information or other certifications that may be required. So you can see here, this is not by any means a comprehensive listing. It's just some samples of different ways in which some courts have approached this. Okay, the Fifth Circuit has published proposed amendments to their certificate of compliance. You can see here that whether it's counsel or unrepresented filers, pro se folks, they must certify that there's no Gen AI program used in the drafting of documents, or if it was used, that everything was reviewed, etc. So you can see there's kind of similarity across these obligations. The ramifications for any misrepresentation is the court can strike the document and sanction the person who signed it. So obviously you want to avoid that. In a counterpoint, I will say there is a judge, 11th Circuit. There was an opinion, a concurring opinion that was written in a case. There's a link here to the case. It was Judge Newsom, and it was an interesting case. And the long and short of it is the judge wrote about a 30-page concurring opinion, and the vast majority of it was not about the legal issues in the case, but rather Judge Newsom, in connection with this case, used a generative AI tool to assist the judge in coming to the conclusion that the judge came to. It wasn't a dispositive. It didn't. The judge didn't rely on the AI tool for like the ultimate legal answer in the case. But as part of using the tool, the judge gave significant consideration to how judges should think about when and how judges should use AI, if they do, and the circumstances where they should use it. Just to go into this just a little bit more, because it's kind of interesting, and there's I mentioned an article here that kind of goes into more detail, but the specific issue that the court relied on this for was to assist it in determining the ordinary meaning of a term that was relevant to the litigation. So this case had to do with a trampoline and someone got hurt. It was an insurance claim. And part of the insurance coverage dealt with whether or not something was an injury, I believe, from landscaping. And the term landscaping wasn't defined in the insurance policy. And so the court turned to the ordinary meaning of landscaping, and it turns out that there is no one single ordinary meaning. And so that was what the court did, was it used generative AI to kind of get a survey of the different ways in which landscaping is defined. And so the court said that, in certain situations, like trying to understand the ordinary meaning of a word, that generative AI tools can be very helpful. But the court, in that concurring opinion, basically laid out some of the, kind of the safeguards that judges should adopt if they do decide to use generative AI to assist. So it's a very, I think, in my opinion, very well written um, piece, concurring opinion that kind of covers these issues from a judge's perspective. And I encourage you to read it, or at least the article that's linked here that discloses it. Okay, unauthorized practice of law. So, of course, the unauthorized practice of law is illegal in most states. And what's interesting is that despite the fact that the legal profession is hundreds of years old, what constitutes a practice of law varies by state. There's not a single uniform definition, and so it varies by state. And so why is that relevant here? There are some AI tools that purport to actually give legal advice, and doing so in most states will be illegal. So giving legal advice typically means representing clients, providing legal answers, preparing legal documents. Those are the types of things that constitute legal advice. In contrast, there's many tools that provide legal information. So if you do a search of cases and you come back with a list of cases, that's not legal advice, that's legal information. And the lawyer would typically review those cases and determine, what's the legal answer to whatever question they're trying to answer based on the precedent. Okay, so that should be pretty clear. But there's a number of tools, I'll cover some in a second, that have actually kind of either come up to or crossed the line of unauthorized practice of law. And it's important, in at least one case, a lawyer was involved in the company, and in a way where there was allegations that the lawyer was assisting in the unauthorized practice of law by being in that role. So what are some of these cases? What are some of these tools? So there's a tool that is called Do Not Pay, and it started out as so-called robot lawyer application. And what the tool was designed to do was to be like a real-time, it would listen to court proceedings in traffic cases, and there'd be an earpiece in the lawyer's ear, or not the lawyer's ear, but the person who was appearing in court, who got the ticket representing themselves. It would basically in real time tell you what to say. Now, in some cases, you can't bring in electronics. That may have been a violation there. But beyond that, this tool was providing real-time legal arguments. And of course, it got shut down pretty quickly as for that functionality as being the unauthorized practice of law. One of the things to be careful about is AI legal chatbots. So chatbots, as many of you may be aware, are tools that you'll find in some websites where some companies use it as a way to engage with customers in the non-legal context, where you can type in information and it will gather the information and try to provide a responsive answer to a client with a customer without having them have to wait on a line, a phone call, or something like that. So if a chatbot is used by law firms or in connection with being able to process legal information, you need to be really careful about that. You want to ensure that the chatbot is not giving legal advice, and you want to really be careful about it even giving legal information. So that's an area to be, kind of very mindful of. One of the other kind of big areas, and I won't go into some great detail, but if it's something that you need more on, there are a number of existing cases on this. There's a difference in some cases between having a tool that assists in filling out legal forms, and in contrast, deciding what forms might be relevant in a particular case. That might actually involve providing legal advice. And again, this varies by state. There's been a series of cases involving LegalZoom and a company called Upsolve, where there's been some, I'd say, conflicting results. But to the extent that you use AI in connection with assisting in filling out forms, I would kind of be mindful of these cases, and depending on which state you're in, decide what is permissible and what's not. In any case, if you use an AI tool to fill out a form or for other purposes, absolutely 100% you need to confirm the factual information that was filled out correctly, if it's permitted to use AI even in that context. Okay. So, yeah, they mentioned like if lawyers are involved with some of these tools, there was one tool, for example, that in trying to get around the unauthorized practice of law, a client would pay to have forms filled out by an AI tool, and those tools would be sent to a lawyer to review. Turns out in many cases there was a very cursory review, and in very, very few cases did the lawyer make any changes. And there was questions as to whether that really got around the unauthorized practice of law in those cases. So if you're involved as an in-house counsel in these cases, I'd really be careful about these issues and really take a look at your state, what the prior cases are, if there's been in your state, and what the rules are in those cases. There's certain tools that are general purpose AI tools that their terms of service prohibit usage for legal purposes, except by a practicing attorney. So, even some of these tools recognize that there's legal limitations. There's another tool that's interesting, and to my knowledge, this is still kind of an unresolved issue, but there's a tool called ClaimCam that uses AI to identify potential class members in class action lawsuits, in exchange for a percentage. And this tool has been used in a couple of big cases that are kind of referenced here. And there were allegations that they're interfering with the settlement administration, and that taking a legal fee for identifying class members was improper. So I think that one is still ongoing, but another way in which AI is being used that may create some potential issues. Beyond the bar associations, the FTC has issued a warning that the use of legal tech that constitutes unauthorized practice of law may also violate the FTC consumer marketing requirements, particularly if there's any inaccurate information or misleading advice that's provided by these tools. There's a link there to the FTC opinion letter on the unauthorized practice of law. Okay, so some key takeaways, and I see a couple of questions in the Q&A that I'll touch on. So I should be clear from all of this. Using AI and generative AI in particular is not prohibited by any of the bar associations that I've seen, by any of their guidance. But clearly, as I touched on today, use of AI can implicate a number of ethical issues, and there may be more than we covered today, depending on what you're using and how you're using it. There are no real specific ethical rules that have been written or amendments made to specifically address AI. So most of this is looking at guidance, and the couple of cases where lawyers have been sanctioned, I would kind of make yourself aware of those, some of the ones that are mentioned in the presentation earlier. And I think you should be constantly vigilant about, as you use new AI tools or consider using them, and if you use them in new ways, give thought to whether those different use cases might implicate ethical rules or might implicate a rule in a different way than things we've talked about already. Obviously, stay away from unauthorized practice of law. Make sure that if you're using AI in connection with judicial or other proceedings, that you understand if there's local rules that address AI, you obviously comply with them, and adhere to the, and do the fact checking, just like you would with any other secondary source. Make sure you supervise your employees, and really it's good practice to have policies for all of this. Okay, so there's a couple of questions here. Let me get to. The first is, given the amount of hallucination with LLMs, which stands for large language models, how useful are LLMs in the legal profession at this time? You know, if any companies are able to certify their level of accuracy. So I think with respect to the first part of the question, there are general purpose LLMs, right? So again, without kind of going too much into naming names, the ones that you see that you use for any purpose, day-to-day purposes, those are not specifically trained on legal documents, right? They're trained on basically the internet, a lot of them. And so they don't have specialized knowledge or skill, and they're not necessarily constrained to things that we know are valid legal documents or principles. So the likelihood that they will hallucinate is greater than the tools that are custom trained on legal documentation. Having said that, both general purpose tools and even ones that are specifically trained on legal information can hallucinate. And so I think the answer is, does that mean you shouldn't use them? You shouldn't use them, or are they not useful for lawyers? And I think the answer to that is no. I think the key is understand those limitations, and don't just use any output as if it's necessarily factually correct. If it identifies a case, do the primary research and make sure that case actually exists. If the AI tool summarize the case, make sure that it's summarized correctly. Do what you would do in other situations. But AI can be incredibly helpful in many contexts. So I wouldn't not use it because of that. I would adhere to the principles we talked about and use it in a way that's ethically compliant and safe. And then the second part of the question, do you know of any companies that are able to certify the level of accuracy? Again, I think through adopting diligence. Look, we all, anytime we adopt a new technology, there's a certain level of diligence that our IT departments go through to vet the tool, whether it's AI related or not. There are some AI specific issues that you want to go through. Again, I would refer you to the NIST risk management framework that I talked about. It's pretty comprehensive, but your IT departments should be kind of aware of that and the risks that can exist, and they should be able to dig down on that. I'm not aware, I'm sure there are, but I'm not aware of any specific third party, consultants that do this type of work, but I'm sure they're out there. And if you don't have the capability within your firm, then I would suggest seeking someone like that. Okay. Next question is, can you define legal advice versus providing information? I wish I could do a better job. There are some of the cases I mentioned by state, it kind of varies as far as what's within the scope of legal advice versus providing information. But, I think as examples, without necessarily being exhaustive, if you're reaching a legal conclusion or representing somebody, preparing a document that's being submitted to a tribunal, that those are more likely to be deemed legal advice. If all you're doing is saying, here are some cases that address this issue, that's going to be more informational, right? And so if it's something that someone will use to, draw legal conclusions as opposed to giving them legal conclusions, you're more likely in the category of information. But I do want to emphasize it is fact specific and varies by state. So what influence has the concurring judicial been had, or do you think will have on AI use and rules? Interesting. I have not seen any direct result, but the judicial opinion from the 11th Circuit, the concurring opinion. But I do know that courts and different organizations that deal with the the Council of State Courts and some of the other organizations that deal with these issues are addressing AI head on, and I'm sure they'll factor that opinion into any rules that they adopt. And then the last question that's here is, are there any suggestions for guiding subject matter experts on using AI and writing their expert opinion reports, or the same guidance you offer the legal profession? I think for the most part, the same thing. Again, like if you have information, like what a lot of times, like ways that lawyers use AI or experts might use it is you might outline a set of issues with bullet points, and you may ask AI to create a first draft based on that. So if the content is yours and you're using the AI tool really just for formatting and kind of expanding it, right? Again, you're probably going to be in a safer point. You still want to review everything that it does and make sure it's accurate, but that's one way that you can use it very easily. If you're trying to get an AI tool to develop expert opinions, that's probably a little riskier. If you're trying to get it to do a search of prior expert opinions on the same topic and summarize those, again, that's probably in the middle. Some of these tools, when they cite stuff, they'll actually provide a link to where if they found information, if they're using like retrieval augmented generation, for example, and you can go back and look at the actual document that was pulled, but it's a good way to get the information and have like a summary of it as a starting point for you to do additional research. Okay. And then, are there key ethical concerns that arise from the use of AI in legal practice? How do they differ from traditional ethical concerns? On some topics like bias and discrimination, that's something that we all need to be mindful of. Anyone using an AI tool needs to be mindful of that. It's not limited to lawyers. But I'd say the key distinction, relevant to this question is that lawyers are subject to higher ethical standards in many situations in dealing with clients than some companies are with their customer. And so those are the bar rules, the ethical guidelines that we deal with every day. And so I think, the applicability of those is going to be the key distinction of where those concerns arise in the legal practice, but not necessarily in some other business context.
Awesome.
I think we got through them all.
Yeah, you did. Thank you so much, James, for that wonderful presentation and for answering all of our audience questions. And thank you all for submitting your questions. We want to thank you again for joining us for another Justia webinar. Again, as I mentioned at the top of today's presentation, for all the lawyers in attendance today, I wanted to remind you all of the benefits of joining Justia Connect Pro. It's available for any lawyer with a claimed profile in your Justia lawyer directory. You can upgrade your membership and get access to additional features, one of which is the AI-powered Justia chat, enabling you to get a whole new avenue of leads for your firm. There are also many, many more benefits to check out, so please feel free to visit us at pro.justia.com. Thank you all so much for joining, and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.